Hi everyone, Amber Cohen here. I am a trial attorney and I absolutely love to watch trials. So this is part of what inspired me to start this channel. This is episode 3. I was going to talk about opening statements. I'm going to save that for episode 4 because I'm just really excited about the Kouri Richins trial, which is going on right now. And for those of you that are watching, obviously we're in the middle of the trial. So watching trials is a little bit like athletes watching film. It's just doesn't get old for me, and it only helps me sharpen my skills. So thank you for being here with me. If you like anything what I'm saying, please feel free to like, subscribe, all the above. I would be internally grateful, as I am only in episode 3 trying to build my think tank here. So if you've been watching the trial unfold, you might feel like you're drowning a little bit in headlines. It does seem to be everywhere, maybe because that's my logarithms. So it's all over my Instagram, it's all over my YouTube. But trials aren't the headlines. They really are puzzles. So today I'm going to step back, ask 3 disciplined questions of you. So what's been proven so far? What do you think is still missing? And strategically, where does the case go from here? Because trials are not about emotions. We did see some emotions. Obviously, it's a murder case. It's hard not to be emotional. But they're about proof. So I want to break it down, talk about what is needed to prove this case. By way of background, Kouri Richins was married to Eric Richins. They live in Utah, I believe right outside of Park City, Utah. My understanding is they have a couple of sons, and they met while she was working at Home Depot. By all accounts, had a pretty fairly normal marriage, I think. She started a real estate flipping business, and she bought homes, had to flip the houses for investment purposes, and I think that he helped her with that. I think he worked in some sort of construction. I'm not sure. I'm not even 100% sure on that. So, but the state alleges that Kouri Richins poisoned Eric Richins, and ultimately he died from a fentanyl overdose. So they have to prove that she poisoned him with fentanyl. They believe, and by they I mean the state and Eric Richins' family, believe that she attempted to poison him before ultimately this last poisoning where he died, alleged poisoning. She later wrote a book, a children's book about grief. She states she wrote it for her children who were grieving for the loss of their father, and there was financial motivation to kill Mr. Richins for Kouri because she was so in debt. She had major life insurance policies that were tied, obviously, to Mr. Richins' death, where she would benefit from that and be able to get out of debt. The defense position, from what I can gather thus far, it's really a circumstantial case, that there's no direct eyewitnesses to the poisoning, and there's some very serious questions about the source of the fentanyl, which I think could go to the intent piece of this case. Questions about the credibility of these cooperating witnesses, and obviously whether or not there's an alternative explanation to the death. For example, is it possible Mr. Richins took the pill on his own and it was an improper pill and maybe he did it? So, from what I know about the case so far, there does not seem to be a confession. I don't think there's any type of evidence that Kouri Richins confessed. I don't think there's a video that shows she put something in a drink or put something in a sandwich. This is what we call a circumstantial case. It is forensically driven. It is motive driven. The state really is going to have to show the motive being the strongest piece of evidence as the intent part of this. So it's going to matter. They're going to have to put that on. Procedurally, the case stands, I think we're going into day 6 of trial tomorrow, so I'm a little bit late on the bandwagon. Sorry about that. But I just needed to get this going. And I've been watching this trial mostly because well, one, it's pretty publicized, but two, it's one of those cases where is the state really going to be able to show that this happened? She was arrested, charged, she's been in custody. There was obviously some preliminary hearings, discovery battles, pretrial practice. I know that there has been some pretrial rulings, it looks like the judge has made. By the way, this judge seems to be very good, very calm, collected. Honestly, from what I can tell, it looks like he was meant to be a judge from day one, because he's just got a very good demeanor and he's very intelligent and is doing a really nice job. But what I think has happened, from what I can tell from the key issues in this case, is the admissibility of prior alleged poisoning attempts. So that would be, I think the family believes that she tried to poison him before. I'm not sure if they're going to be able to get that in. I don't even know if they have any evidence of that, but I think they know that he got sick after a sandwich one time, and he got sick maybe after a prior drink. Not sure. They want to look at that as prior pattern evidence. They've got financial records and insurance evidence to show, I think, that potentially that was her motive. And text messaging, which I know there was a little bit, but I think there's more text messages and digital evidence. I think we're going to be coming into that next week. And there's obviously a cooperating witness, jailhouse witness, and ultimately the forensic toxicology is going to be an important part too. From the trial perspective, from my perspective, the case is going to rise and fall on these evidentiary rulings. It's going to. If he doesn't allow it in, I don't see how the state's going to be able to prove the case. If he allows some of this stuff in, and the state's allowed to show a pattern story with the intent, then the lanes become much wider. The state's going to have a lot more room to be able to show beyond a reasonable doubt that this was her intentions. But without that, that lane gets really narrow. It gets much harder to prove. And ultimately, I think you're asking the jury to make a huge leap. And when you're sitting in there in that jury box, I just don't know if they're going to be able to do that. So the prosecution is going to have to prove really three things. And it starts with, very simply, the fentanyl. The state is going to have to show that Kouri Richins, beyond a reasonable doubt, we're not probable cause stage, we're not at the beginning of this case, beyond a reasonable doubt, which we'll go through later, but the state must prove beyond a reasonable doubt that the fentanyl is what caused the death. Now, we know that. We heard that. I think the medical examiner was pretty credible. I don't know if the jury's not going to accept that, but that it was intentionally administered. This is the piece that I think is going to be really hard for the state to show. And I don't know what I'm like you, I don't know what's coming next, so they could show it. But the defendant was the one that did it. Lastly, not suspicion, not the family didn't like her, not that, the family's upset with her, they have, this inkling. Not because it's a bad marriage, not because she acted strangely, not because the life insurance only alone was changed. There has to be some proof. Now, the state is allowed to rely on what's known as circumstantial evidence. Circumstantial evidence isn't direct evidence. It isn't evidence when you have someone who says, I saw this happen. They get to build the case around things that have happened and allow the jury to infer from there. So in a circumstantial poisoning case, prosecutors are typically going to build around the toxicology report. So we have to accept that he was, in fact, had fentanyl in his system, and that was the cause of death. The state has to prove that there was access to this substance. And of course, that the opportunity was there for her, for Kouri Richins, that there was a financial motivation. And ultimately, I think they're going to have to show that there was some incriminating communications. Even if one of these pillars weakens, then I think the jury's confidence is going to shift in this case. That opening statement by the prosecutor of Bloodworth was pretty serious. So they're going to be looking for him to prove that case. And if he can't prove what he said, then the jurors don't need to know what happened. They only have to find reasonable doubt. I think that defense strategy so far has been to really shine some light on, well, what I have seen at least is that it signals that they are going to really challenge the reliability of these cooperating witnesses, right? So we've heard from the maid, who was the one that apparently coordinated the drug dealer, and then we heard from the source, the drug dealer, who was really, honestly, not that helpful. I'm not even sure. I'm sure the state is very not happy with him. He had an immunity deal. Besides the fact, it looks like he was telling the truth. I'm just not sure it was what they needed to prove this case. So they're challenging the reliability of the cooperating witnesses, undermining the chain of custody, highlighting alternative sources of fentanyl, and obviously attacking the motive, right? Exaggerating or speculative, not that this is what she wanted. So this is clearly what we call classic reasonable doubt layering. This is their theory of the case, reasonable doubt. In high-profile poisoning cases, defense attorneys often avoid over-arguing innocence because it's not going to win. It's burden shifting. The state, the government, is the one that has the burden to prove this case. So instead, they're going to ask the jury, can you eliminate every other explanation? And if the answer is no, then that's the acquittal. So if you can't say for certain, beyond reasonable doubt, right, that fentanyl was put in Mr. Richins' body by Kouri Richins, then it's an acquittal. And it'll be curious to see what else the state has. We're only halfway. And this is why they tell jurors to stay offline, don't look at the media, don't look at the internet, don't read any commentary, because the evidence is still open. There's a lot left, probably, I'm guessing, for the state to show. So what happens next? Well, this is what we're going to watch for going forward, right? The forensic testimony. So if the toxicologist is clear and confident, then that helps the state. If the cross-examination exposes gaps or substances, that helps the defense. These cooperating witnesses, any inconsistency matters. Any plea deals matter. Jurors are extremely skeptical and incentivized of incentivized testimony. I'm sorry. I was just reading something on the computer. Again, just episode 3. So working in some strategy, trying to figure out what works best. So apologize. Anyway, jurors are extremely skeptical of incentivized testimony, meaning when you have the Robbie, who is the drug dealer who had the immunity, he clearly, was given immunity, but he didn't necessarily play into it. He wasn't trying to say absolutely, what the state wanted. Now, mind you, he probably didn't want to be linked or at all associated with the death, because if in fact he sold that fentanyl, and if in fact it killed Mr. Richins, that could have been a problem for him, but he has immunity. Although I'd be curious about hearing of any other deaths in that area. He did seem to think that, he wouldn't do that because fentanyl kills, and he was pretty clear about that. But anyway, Nicole, who is the person that connected, I believe, Carmen to Robbie, there was some testimony in there where one of the police officers, I believe the detective that was on the case, was, sorry, the dog is sleeping and she's crying. She's like daydreaming or something, I'm not sure. Anyway, so if the witness is incentivized, then they're going to probably, the jury is probably going to have some questions about that. And I think the biggest piece of that was Carmen, because obviously she was promised immunity. She, I think, flipped her story. She started to say it was oxys, then went into fentanyl, talked about Michael Jackson drugs. I don't know. So next thing they're going to be looking at is, does it feel like the financial motivation is enough? I mean, that's a lot to swallow. I mean, obviously people have killed for money. We see it. We know it happens. But is it compelling, or is it speculative? Is it the family just grieving and upset and looking for someone to blame? Motive isn't required. However, jurors tend to want to feel certainty when they're convicting. So they're going to want to understand the why. But it's not an element. The state does not have to prove it. The defendant's demeanor. Now, this is definitely not an element. However, and it shouldn't matter, but jurors are human. We talked about this in episode 1, and that is that they judge constantly. We judge when we meet people. We judge when we look at people. It's instantaneous. We can't help it. We're human. So they're judging her. They are judging her throughout this period of time, watching her. Now, big picture, high-profile trials distort perception. So people think she wrote a book, so that's suspicious. Or there are marital issues, that's suspicious. But courtrooms are disciplined environments. The jury is not deciding whether someone is unusual, or they are deciding whether deciding whether a book is unusual. They're deciding whether or not the state's met its burden. And that's it. That's the question. And if the burden of proof is the most powerful protection in our system, honestly, it really is. So where are we right now? We're in a case that depends heavily on circumstantial alignment, forensic clarity, witness credibility, and really narrative cohesion. So if the prosecution story that they opened up with, it feels seamless and they were able to prove those points that they made, this story, then conviction is going to be likely. However, if it feels stitched together, if they're missing some pieces, the doubt's going to creep in, and doubt wins cases. Now, I'm going to try to continue breaking down the case and the evidence throughout the week, not from a headline perspective, but from a trial strategy perspective, because watching a trial is one thing that I love. And understanding how it's being built really is an entirely different thing. So I plan to see you at the next episode. And of course, if you like what you saw, please like or subscribe. And thank you so much.